The following is a presentation about the settlement of the pending pension litigation. It is filmed for the benefit of public employees, teachers, retirees, and the general public. You will see an explanation of court-ordered mediation, a description of the legal process and the future steps to effectuate the settlement. There will be a discussion of the specific terms of the settlement proposal, the costs of the settlement proposal, and there will be made available other resources where you can learn additional information about this settlement. Hello, I'm Richard Leach. I'm the Director of Administration for the state of Rhode Island. I'd like to explain to you at the outset what is court-ordered mediation. Mediation is a respected and common dispute resolution mechanism. It's designed to help parties who have differences resolve those differences without litigation. Mediators act as an intermediary between the parties. They help them guide them to find solutions or resolutions to their differences. Sometimes they meet separately with the parties, sometimes they hold joint sessions with the parties. The mediators cannot impose a resolution. They can only help the parties find common ground. In the case of the pension litigation, the Superior Court of Rhode Island ordered the parties to mediate, and what you're going to hear about is the result of a successful process that reached a proposed settlement that will be first presented to the members of the parties that sued, or the plaintiffs, and then all affected members in the retirement system. That means union and non-union public employees as well as retirees. They will get a chance to vote on the proposal, and afterwards the court will determine if the settlement proposal is fair, and then it will be presented to the Rhode Island General Assembly for action.
My name is Lynette Labinger, and I'm one of the attorneys for the plaintiffs in the cases that are being settled through this mediation process. I've been asked to walk you through the legal process that is contemplated by the agreement and to give you a background as to what has brought us to this point. In 2009, the General Assembly passed a round of pension changes that altered the benefits for certain active employees of the state and public school teachers. Then in 2010, the General Assembly made a second round of changes affecting those individuals. And in 2010, complaints were filed on their behalf, on behalf of state employees and teachers' unions challenging the 2009 and the 2010 changes. In November of 2011, the General Assembly enacted the Rhode Island Retirement Security Act, also known as RRSA, which made more changes to those members and also affected members of the municipal employee retirement system, both municipal general employees and public safety employees, and also made changes to retirees of all of those systems. And in June of 2012, complaints were filed by public sector unions and retiree coalition representing those individuals affected by the changes, challenging RRSA. July 1, 2012, RRSA became effective. The lawsuits continued. On January 2 of 2013, the court to whom those cases had been assigned ordered all of the parties into mediation. Along with the mediation order was an order by the court imposing a requirement of confidentiality on the parties participating in the mediation. That mediation continued until February 14, 2014, and the parties have now signed a settlement agreement, and the court has modified its confidentiality order. Let me tell you who the plaintiffs are in these cases. They are union and retiree coalitions asserting the interests of their members. And generally speaking, those members include state employees and teachers with 10 or more years of service as of June 30, 2012, and general municipal employees participating in MERS, which is the Municipal Employees Retirement System, as of June 30, 2012, some of them with 10 or more years of service, and others simply as of June 30, 2012, where collective bargaining rights are asserted. And the same is true for those firefighters participating in MERS fire units and police officers in MERS police units. In addition, there's a coalition of retirees representing their retired members as of June 30, 2012. The defendants, the governor of the state, the general treasurer of the state, and the retirement board of the employees' retirement system through its executive director and its chair, Frank Karpinski, the executive director, and the chair, the general treasurer of the state of Rhode Island. So these parties have all agreed on a settlement agreement which contemplates many steps before final approval can be achieved. The first step is an initial vote that is presented to the members of the plaintiffs, the retiree coalition and the union members, for a vote which will be held within 60 days of the settlement agreement. Before that vote is conducted, the members will be provided information through a variety of formats. Those will include this video that you're watching right now, informational meetings, mailings, question and answer on our website. The plaintiff members, when the vote is conducted, will vote in separate groups. And within those groups, if more than 50% of any one group votes to disapprove the settlement, then the settlement does not proceed and the litigation continues. If the settlement proceeds after the first vote, the next step is for the plaintiffs to ask the court to permit them to amend their complaints to proceed as class actions for settlement purposes only, and to obtain preliminary court approval of the proposed class settlement. These classes are described in the settlement agreement itself. Generally speaking, they're expanded versions of the groups that I've already described to you to include individuals who share the same characteristics but are not part of either the bargaining units or the retiree coalitions. So additional state employees who are both in other unions or non-union, additional retirees. And they will all be part of the class if the court approves class action status and allows us to proceed to present the proposed settlement to them. If the court preliminarily approves the settlement and the class action structure, then the classes will be given notice of the proposed settlement and their right to vote on the settlement proposal class by class. They will also be given notice of their right as individuals, regardless of what their class vote does, to object to the settlement and to be heard by the court at a fairness hearing. Voting will occur on a class-by-class basis within 45 days. In addition to the individuals allowed to vote in the first vote, non-union employees and all retirees will be included in this vote. If more than 50% of the members of any one class disapprove the settlement proposal, then the settlement does not proceed and the original litigation continues. If no class disapproves the settlement proposal, the next step will be for the court to conduct a fairness hearing at which it will hear individual objections and determine whether or not to approve the settlement proposal. If the court approves the settlement proposal, it will direct that final judgment will enter, provided that the General Assembly adopts the legislation that's part of the proposal. Action by the General Assembly is a necessary step in this settlement. The court, the parties, and the mediators have always understood the fact that the General Assembly is the only body that can decide whether the settlement proposal can and will be affected by a change in the law. So if the court conditionally approves the settlement proposal, then the General Assembly can take any action it deems appropriate, including any one of the following three actions. First, the General Assembly can pass the legislation which is part of the settlement proposal. If the General Assembly does that, then the settlement proposal becomes a final agreement and a judgment, and all parties and all members and retirees covered by the class action proceedings will be foreclosed from challenging the legislation and will be bound by the settlement. Second, the General Assembly can take no action. In that case, the settlement proposal will be of no further force and effect, and the original litigation will continue. Third, the General Assembly can pass legislation that is different than what is included in the settlement agreement. If it does so, the original litigation continues. The reason for this is because the plaintiff, union, and class member votes, as well as the court's fairness hearing, are based on the exact terms of the settlement proposal. Those votes and the fairness hearing will no longer be binding if the terms of the settlement proposal are changed by the General Assembly. All parties will support the settlement throughout this process. All parties are committed to the settlement. All parties are committed to advocate for the passage of the legislation, and all parties have agreed that during this legislative session, they will not advocate for any other legislative action relating to retirement benefits other than adoption of this legislation.
Hi, my name is Mark Dingley, and I'm from the General Treasurer's Office. And today I'm going to be talking about the benefit changes in the settlement proposal. We tried to achieve a balance in the settlement proposal. We wanted to preserve the essential principles of the Retirement Security Act, which were to make sure that benefits will be payable to our retired members, while having a system that's sustainable for our state and our municipalities. At the same time, we wanted to address some of the important concerns of the members of our retirement system. First, I'm going to address the changes to the cost of living adjustments. The best way to read these slides is to look at the columns first. The columns are always organized first looking at either pre-litigation or pre-Retirement Security Act, then the benefits provided under the Retirement Security Act, and in the final column, the benefits provided by the settlement. In this slide, first the COLA base. Prior to the litigation, and this is the first litigation in 2009, the COLA base was unlimited. Under the Retirement Security Act, the COLA base is $25,000, and that same COLA base is maintained in the settlement proposal. The amount of the COLA changes in the settlement proposal. So prior to the litigation, it was 3%. Under the Retirement Security Act, it was based solely on the investment earnings of the pension fund. And under the settlement, we have a hybrid COLA. We have a COLA that's based 50% on the investment returns of the pension fund and 50% on the cost of living, the CPI-U. What this does is this increases the likelihood that when cost of living goes up, our members will receive a COLA or an additional benefit adjustment. Under these COLA provisions, the maximum COLA prior to the litigation was 3%. Under the Retirement Security Act, the maximum COLA was 4%. Under the new settlement proposal, the maximum COLA is 3.5%. Half of it is based on the maximum under the Retirement Security Act, so that's half of 4% is 2%, and the other half is based on the CPI-U, so 1.5%. The minimum COLA was 3% prior to the litigation. Under the Retirement Security Act, it was 0, and it remains at 0, meaning it will never create a reduction in anyone's pension. This next slide deals with the COLA timing. Prior to the Retirement Security Act, the COLA was paid every year. Under the Retirement Security Act, the COLA is paid when a plan's funded ratio is 80% or greater, and that same standard is maintained under the settlement proposal, 80% or greater. Under the Retirement Security Act, there was an interim COLA paid once every 5 years. Under the settlement, that changes, and the interim COLA is paid once every 4 years. Under the settlement agreement, there's also a one-time COLA payment that's payable as soon as possible after enactment of the proposed legislation. The amount of that COLA is 2% on the first $25,000 of someone's pension, and that amount is added to the pension base of our members. This next slide deals with proposed changes for state employees, teachers, and MERS general employees who have or had 20 or more years of service as of June 30, 2012. When I'm talking about those members with 20 or more years of service, I'm talking about total years of service. This includes their contributory service as well as purchase service, as long as that service was purchased or applied for purchase prior to June 30, 2012. For these individuals, the Retirement Security Act remains effective through June 30, 2014. So the first 2 years of the Retirement Security Act remain in place. Effective July 1, 2014, these members no longer participate in the defined contribution plan and participate only in the defined benefit plan. They will keep their accumulated amounts in defined contribution, and those will continue to grow in future years. Under the defined benefit plan, you can see the columns at the bottom talk about the prior to the Retirement Security Act. Under the Retirement Security Act, the accrual rate was 1%. Under the settlement agreement for members with 20 or more years of service, the accrual rate increases to 2%. On this slide, we address the increased cost for employees of the changes we described on the prior slide. Again, this applies only to employees with 20 or more years of service. Contribution rates will increase for these employees compared to the contribution rates they were making under the Retirement Security Act by 2.25%. What that means is that going forward after July 1, 2014, state employees and teachers will contribute 11%, and MERS general employees will contribute either 8.25% or 9.25% if they have a COLA. We also have changes for state employees, teachers, and MERS general who have less than 20 years of service as of June 30, 2012. For these employees, the hybrid DB-DC, or Defined Benefit Defined Contribution Plan, remains in place. The accrual rate under the Defined Benefit Plan remains at 1%, and under the Defined Contribution Plan, there are new contribution rates for the employer. For those employees who had 15 but less than 20 years of service as of June 30, 2012, they contributed 1% under the Retirement Security Act. The employer contribution increases to 1.5% under the settlement proposal. And for those employees with 10 and less than 15 years of service, the contribution rate increases from 1 to 1.25%. For those members with less than 10 years of service, contribution rate remains at 1%. There are additional changes which are to the retirement age under the Retirement Security Act. For those members employed on June 30, 2012, they will be eligible to retire at the earlier of their retirement age under the Retirement Security Act, or age 65 with 30 years of service. With respect to early retirement reduction rates, we have members who are eligible to retire once they have 20 years of service and are within 5 years of their retirement date. Under the Retirement Security Act, each year they retired before their actual retirement date, there was a 9% reduction in the benefit. Under the proposal, the reduction rates are 9% in the first year, 8%, 7%, 7%, and 7%. This next slide addresses changes that were made with respect to members whose earnings are less than $35,000 a year. First, under the Defined Contribution Plan, they will not be charged any administrative fee. The fee currently is $40 a year for these members. The second change is for part-time employees. Under the Retirement Security Act, an anti-spiking rule was added for these employees. And under this change, these employees will have their benefit based on the greater of their highest 10-year average earnings or their highest 5-year average earnings. For correctional officers, prior to the Retirement Security Act, in their years following 30 years of service, so for their years 31 through 35, they received accrual rates of 6%, 5%, 4%, 3%, and 2%. Under the Retirement Security Act, this changed to 2% for each year, and under the settlement proposal, that 2% is increased to a 3% accrual rate for those final 5 years. This slide addresses the changes for our public safety members in MERS. I'm going to draw your attention first to the second row here regarding retirement age. Prior to the Retirement Security Act, there was no age requirement for retirement purposes, and members could retire after either 20 or 25 years of service. Under the Retirement Security Act, members were required to wait until age 55 with 25 years of service. Under the proposed settlement, for those members who were employed on June 30, 2012, the eligible retirement age is age 50 with 25 years of service. In the first row, you can see the contribution rate, which stayed the same before the Retirement Security Act and during it, which is 7% or 8%. And under the settlement proposal, these members will be required to contribute an additional 2% employee contribution to receive the earlier retirement age. Under the final row, we have added an additional accrual for those members who wait until age 57 to begin receiving their retirement benefits, provided they have 30 years of service. These members will, under the settlement proposal, receive an accrual rate of 2.25%, which is applicable to all of their years of service. This concludes the description of the benefit changes under the settlement proposal, and we believe that these benefit changes serve the important purposes of the Retirement Security Act, which is to preserve the security of our members' pensions, maintain a sustainable plan for the benefit of our state and our municipalities, and to avoid protracted and expensive litigation.
I'd like to share with you the costs of the settlement proposal. The goal in reaching this settlement was to make sure that we had a predictable pension system that was safe and secure for our retirees while still affordable for the taxpayers of Rhode Island. You're going to see on this slide and the next several ones a lot of numbers. I'm not going to take you through each and every number. I'm going to focus on the bottom three lines, which deal with the total costs and how those are broken out between the state of Rhode Island and the municipalities. I also have to explain that these costs will take effect beginning July 1st, 2015, approximately 16 or 17 months from now. They will not affect the current budget that's before the Rhode Island General Assembly or the budgets of local municipalities. So before there was any Retirement Security Act, the annual cost in fiscal year 16 for all of these systems would have been $886 million. Under the Retirement Security Act, that cost was reduced to $486 million, approximately a $400 million decrease. The settlement increases the annual expense slightly to $510 million, or $24.2 million. That means that the annual cost is about 5% higher. But that cost is broken down, $13 million to the state budget and $11 million to our municipal budgets. But it is an overall reduction of 42% in the payments that would have been made if the settlement never took place. This slide talks about the unfunded liability, which really means the cost of benefits that hasn't yet been paid for. Prior to ERISA, that cost to the state and the municipalities was $8.9 billion. With the enactment of the Retirement Security Act, that was lowered to $4.8 billion. Again, it is increased under the settlement to $5.054 billion, an increase of $232 million, which will be paid for over the next 23 years, which is the period of amortization of this unfunded liability. Again, that can be broken down between the state and the municipalities. The state will pay over this period of time $123 million, and the municipalities $109 million. And the state's share will be a little over $3 billion, and the municipalities almost $2 billion. But again, you should compare that to what it was before ERISA was enacted. So the total reduction in unfunded liability for the state is $2.2 billion, and for the municipalities, almost $1.7 billion. Lastly, people talk a lot about the funded ratio. You hear about that, and it really goes towards the health of a pension plan. The settlement does reduce the funded ratio, but we believe it is only a slight reduction. For the state employees and the state teacher and all teachers, it's 1%. It's a little higher on the average for our municipal employees, and again, that would vary by individual community and plan, but the average for general municipal employees is 1.8%, and for MERS, police, and fire, it's 2.8%. But again, these plans are much healthier if you compare the settlement numbers to the pre-ERISA numbers. This completes our presentation, but there's a lot of other information that you can find if you go to the website, which is ripensioninfo.org. On that website, you will find all the documents that deal with this settlement. You will find the actual agreement with the exhibits, including the proposed legislation. You would also be able to find the letter from the state's actuary, which gives precise information about the costs, including costs by each and every city and town. You'll also be able to read some frequently asked questions. So the important thing to remember is that this settlement, if approved by the General Assembly, will bring to an end all the litigation. 3 years of litigation challenge. It will make sure that costly and time-consuming and expensive litigation will be over, and there will be some certainty and there will be security for our pensioners.